into our solutions around GBV, because if we're going to help people rewire their heads, their head spaces, and find tools to modulate or regulate their emotions, their thought processes, then they're not likely to respond to disagreeable environments by lashing out violently. So that's a question for all of you. And then I have one specific question for Prof. Collins. You raised something that we don't think about very frequently about GBV, including experiences of men that are not directly related to how they relate to women, but they relate to gendered expectations about roles. When I tweeted about the war, the Russian war on Ukraine, and I said the war, women bear the brunt of war. Some men tackled me and said, how do you say that? It's men that are forced to go to war, it's men that are conscripted, etc., etc. So it made me think. But here's the problem, though. There's still gendered power relations between men and women. So if you start defining GBV in ways that are inclusive of the experiences of men and women, how do you prevent men leveraging their power to hijack the dialogue in such a way that the people who bear the brunt of GBV are lost in translation, and men again, unintentionally, find themselves interpreting the experience of GBV to mostly deal with their own experiences. And this is the same when it comes to feminism, for example. High-powered feminists tend to see all gendered struggles in terms of their own lens. And even with GBV, for example, you see now that women in business have prioritized the issue of tenders as a way of responding to GBV, but it won't respond to what we're talking about, what happens to students on campus, what happens to the Gogodlaminis in Tsofimvaba who are not going to be assisted by tenders. Thank you.
Okay, Prof. Collins, I think we'll just go straight to you, and then we can just look at the neuroscience question with the rest of the panelists, but just your answer to that assertion.
Okay. Thanks, Prof. Madonsela. Such a subtle and intricate question that you've asked that opens up so many things. I want to talk for an hour to answer your question. But yes, absolutely. I'm very conscious when I start saying, well, we need to talk about the way in which there's gendered violence against men. What we don't need to do is then just center men as being like the whole conversation now about when men, once again, women are taken off the table, marginalized, silenced. Absolutely not. We cannot allow that to happen. And yet we need to move away from a kind of a 1970s American feminism of like men are the enemy, men are just, all men are rapists, that kind of nonsense, which isn't analytically helpful. So there is this very delicate, subtle process of saying, well, we need to also talk about the violence against men because of their gender, which is then by definition gendered violence, without that then hijacking our conversation. And the point that I tried to just hint at, but I didn't have a chance to elaborate it, is one of the reasons we need to do that is because if we don't do that, we're going to carry on creating violent men in society. And for me, one of the reasons we need to talk about masculinities and the way in which we create masculinities, because we're creating violent masculinities. And we're creating violent masculinities by being violent to men as they develop towards boys in particular way. We are humiliating, we're beating them, we're doing all kinds of things to vulnerable young boys that are then producing these toxic masculinities. So if we're serious about getting rid of the toxic masculinities, we have to look at them in terms of how they are created socially. And that then plugs in directly to the first part of your question, which is you were wanting to talk about the kind of neurology. Now, rather than talking about the neuroscience of it, because neuroscience is a lot of different things, I would say what we need to do, and because this includes the kind of neuroscience that you're talking about, we need a trauma-informed theory. And part of trauma-informed theory is understanding how experiences of violence and victimization, abuse, marginalization, neglect, all of those are developmentally then produce certain kinds of emotions, certain kinds of emotional regulation, certain kinds of explosiveness. And so I would guide us towards the language of trauma-informed theory rather than just neuroscience. Trauma and I've kind of lost myself there. Sorry, I was trying to answer so many different parts of your question, which I just think are wonderful questions.
Thank you so much, Prof. I don't know if any of the other panelists, Lisa, Prof. Bonner, or Bronwyn, want to also reflect on that question around neuroscience at all from Prof. Madonsela.
Chair, maybe. Oh, okay, Lisa.
Okay, I'd like to make a couple of comments and also just to respond to something to a few questions in the chat box, if that's okay.
Perfect. Thank you, Lisa.
I mean, people have asked about the coercive sex academic corruption question, and I think one of the ways in which to deal with this is to introduce very clear and explicit policies on relationships within the university context. Some of this work we did for the ministerial task team suggested that the vast and overwhelming majority of universities are absolutely silent on this. And when you look at where students speak about where this has happened, they talk about it being a norm to date your lecturer. And that is the context in which this starts to flourish. So I think that is one very clear way in which to introduce this, to be very explicit about what is the nature of relations between staff and students and even between staff. So that might be one way to deal with some of these issues. The others, I think, also for universities that are within a geographical areas, to think about how do they share resources. Could they perhaps be sharing a chair, a tribunal chair amongst 4 or 5 universities, for example? How can they train each other? How can we look at redistribution of resources between universities? So those might be some of the ways in which we address inequalities. I think in response to what Prof. Madonsela asked, I think there are a couple of things. The first, I think, one of our problems is our model of power. It's very much a dominant suppression model. One person possesses power, the other doesn't. And I think we need to move to far more fluid and complex understandings of power, because that's not adequate to always explaining what's going on in situations of violence. It also doesn't accurately capture, I think, and I want to pick up again on Prof. Madonsela's other point, that women, just like men, are not an homogeneous category. They are simultaneously possessed of vulnerabilities as well as possessed of advantages and privileges. The same goes for men. And so in situations, you will find complex things going on. It's not just about male, female. It's about how is masculinity and femininity in this interaction being shaped by race, by being shaped by class, being shaped by education, being shaped by religious background, etc., etc. So I think we need to move to models of power that are much more complex. I'm not even sure that, I'm sure people will find this provocative, is that we should start to think about patriarchy as being an historical mode of masculine domination that doesn't necessarily capture the complexity of where we are today, as to how it is that some women can simultaneously hold power because of their economic position, which will disadvantage other women who do not have that same level of economic power, so that we end up focusing on things like procurement and tenders, which, as Prof. Madonsela points out, will do very little for what are probably the majority of women in South Africa. So I think we need to start looking towards those more complex notions of power that will help us to understand what goes on in situations and how we interrupt and deal with those very complicated systems of power, which I think may also take us towards thinking about gender in these complex ways. How does gender interact with all these other dynamics that are going on in any one situation at any given time, and will hopefully, I think, prevent the centering perhaps of men, but I think, again, if we also recognize that, and this has been hinted at, if we look at, for instance, the experiences of men when they are racialized, that may result in very different justice outcomes, how violence is interpreted, etc., etc. So if we can start to move towards something that reckons that understands the complexity of people and of situations, I think that may also help us to get to a different position. And I think also I would caution against seeing everything through a trauma lens. There is no doubt that violence has an impact. But one of the things that concerns me, and I say this particularly in relation to judgment, is that trauma becomes the measure of how wrong something is. And I don't think how badly you are affected ought to be a determinant of whether or not something is wrong. Something is wrong, whether I am slightly traumatized or deeply traumatized, it's wrong. And why I problematize this emphasis on trauma is you see it starting to affect sentencing. Oh, this woman, and I've seen this in a judgment. Oh, she's now in a relationship. She has a boyfriend again. She's doing okay at school. Clearly, she wasn't that traumatized, and therefore we are not going to give the accused such a heavy sentence. That is a very slippery sliding slope. So neuroscience can take us down that path, and so can trauma. We need to be thinking about these things are wrong, irrespective of impact. They are just wrong. People don't have to be traumatized or force themselves into a trauma mold before we take things seriously. So those are just some thoughts and responses.
Thank you so much. Unfortunately, we're going to have to wrap this plenary up, but I think all of you have contributed so substantially to a nuanced and, kind of evidentially sound understanding of how we should be looking at GBV and how the kind of stereotypes that we carry into that conversation can actually do deep damage and unnecessarily so. So thank you for centering this conversation. We appreciate each and every one of you. And I think also a lot of people asking Prof. Bana if your PowerPoint presentation is available. If you could make it available to the group, I think everyone would appreciate that because there were so many great points raised in it. But thank you very, very much.
Thank you very much.
Guys, we're going to move into our second plenary now. It is not going to be as long as the first because one of our panelists is unfortunately unwell. She's been hospitalized, and we will break for lunch after this. But our next panel is on critically analyzing the legal, social, psychological, developmental, economic, and human rights impact of gender-based violence in institutions of higher learning. The first panelist is Dr. Sheena Swemmer. She's the head of Gender Justice Program at the Center for Applied Legal Studies, CULS. CULS is a public interest law clinic based at the University of Wits, which focuses on the realization of the rights in the Constitution through research, advocacy, and strategic litigation. She's an admitted attorney and litigates in the field of gender and violence. So welcome, Dr. Swemmer. We look forward to your address.
Thank you so much, and thank you for having me. So today what I'm really going to focus on is a legal approach or a human rights approach and how this affects or could affect universities. So I'm going to ask the question, do universities have a duty to prevent secondary trauma through speedy and victim-centered sexual misconduct hearings? So to just give a basis for this, last year the Constitutional Court released its judgment on the Andy Kawa case. And Andy Kawa is a well-known gender-based violence activist. What I really want to look at is how can the law affect, or does the law affect and create duties for universities with regards to gender-based violence? And that's why I know I'm going a bit around in circles here. That's why I had Andy's case. So let me go from there. So I'm going to argue that we should look at Andy's case and really look at the applications for the university centers dealing with sexual misconduct. So just to start with, So Andy's case really dealt with, she was brutally raped about 12 years ago. She was kidnapped. She was held overnight by the rapist and the kidnapper. And when she could finally break free, she did. She went to she went to the police, and the case really focuses on the police and the police inaction in this case. And I say this happened 12 years ago. The case has been going through the various court systems for 12 years, having gone through the High Court, the SCA, and finally finishing in the Constitutional Court. And I know in one of the earlier presentations, this case was referred to, insofar as it really deals with what happens when the police don't reach a sufficient standard of investigation, and this causes secondary trauma to a victim. And this case really did encapsulate this idea of problematic investigation by our police, which many survivors of sexual violence experience. So with regard to Andy's case, there were two parts that were problematic. It was both the actual search for her. There had been a search for her. There had been a plane that flew over the area to search for her, but it wasn't done correctly. But there was also a problem with the investigation part of her matter, of her case. And the Center for Applied Legal Studies, which I work for, we intervened as an amicus, but we really focused on investigated a lot of the problems that our clients were experiencing with regards to investigation in their cases. And these were things like the perpetrator had been identified by other witnesses, and we see this a lot, yet no one was picked up. We see often that the police don't follow up with the complainant at all. This happened in Andy's case. She had to be the one following up with them, and then she was deemed to be a nuisance. We have other things like evidence not being retrieved, which we often see as well. And this process of Andy having to almost patch together her own case created a situation where she was traumatized by the inaction of the police, who have an obligation to act. So with regards to the specific case and the importance that a couple of important strands I want to bring through to my discussion on universities and their obligation is that the court said this, and this is around the state's duty to protect and prevent the violation of victims. So the state has a duty to protect women against all forms of gender-based violence that impair their enjoyment of fundamental rights and freedoms. It has to take reasonable and appropriate measures to prevent the violation of those rights. And I understand, as previously has been stated, we don't want to just focus on women, but in this case, this was specifically a woman who had been subjected to this gang rape. So what the court is saying is that the state has an obligation to act, but the state also has an obligation to prevent. So we have prevent, we have that they should have a duty to protect, and we also have the duty that is around the investigative process, which we're going to come into now, with regards to what the Constitutional said with regards to investigations. So in relation to investigations, the court said two really important things. And the first was that the investigation, so this was into Andy's case, was not deficient because it failed to result in a successful prosecution, which we do have a problem with generally, of the applicant's perpetrators, but because the methodology was flawed. The police failed to act diligently and with the skill required of them by the Constitution. And then with regards to this is where the issue of the secondary victimization came in. The court said, with regards to secondary victimization, thus, I agree with the High Court that, if anything, not imposing liability would have a chilling effect on the ability of survivors of gender-based violence to vindicate their rights and hold the SAPs liable for any secondary victimization that is caused. So what we had really dealt with in this that's important in this matter is that the court had said, yes, ordinarily we give damages to people. Say an individual rapes you, you can do a damages claim against them for the harm they've caused you. But in Andy's case, she was successful in receiving damages because the police had failed in their constitutional duty to act in certain ways and a constitutional duty to perform certain acts in their investigation. So it wasn't about whether ultimately a perpetrator was found guilty, but it was that the police used whatever resources they have, and we acknowledge those resources are limited, they used in the proper way and in a way that is required by them in the Constitution. And what myself and what Coles would argue is that way includes an investigation that is a victim-centered one. And an investigation that is a victim-centered one has characteristics that are trying to reduce the trauma experienced by that individual. So what would those types of things be in a police investigation? So those types of things would be things that are in our victims chart already, such as you should be updating the complainant around the case. You should be trying to remove the perpetrator from the neighborhood that they're in so they don't have to see them all the time. You're taking active steps to negate these types of things. And many of these things are already in our victims charter but need to really be expanded upon. So what about now looking at Andy's case and applying it to the instance of the university and the various tribunals or gender equity offices universities have? Well, with regards to whether universities have duties or not, I actually posed this question to my colleagues at Coles, and they gave me tons of reasons why universities have similar duties as our police, and things were like included in labor law or duty of care under DLIT and international treaties. But the one that was really the simplest was that the universities are considered to be having equal duties as states as they are state entities in various ways. So in terms of this, universities have the same duties as the state under Section 7 of the Constitution. And this section says the state must respect, protect, promote, and fulfill the rights of the Bill of Rights. And when we look at the rights of the Bill of Rights, that's a right of all individuals to be free from all forms of violence. And when we look at those forms of violence, it is both the prevention of violence, but also how they deal with violence once it happens. So I argue that universities really have to start considering that they owe more than just a protective mechanism, protecting students from violence on campus, from sexual violence, but they also have a legal and constitutional obligation to have systems in place that offer victim-centered approaches to dealing with acts of or perpetration of sexual violence. So what exactly do we mean by this when we look at it in the university context? Is we want systems in place, and many universities that I've worked with have done huge amounts of work and progress towards actually, and Bronwyn had said this, towards actually adopting a victim-centered approach. Like Bronwyn said, with the university she works with and having complainants be able to be represented. But we want approaches that are non-adversarial. As Bronwyn said, we can be creative. We don't have to replicate the criminal justice system in being adversarial. We can be inquisitorial. We can say this is not a system where we are fighting or we are relying on demeaning the complainant through cross-examinations and things. This is a system where we want to come up with, we want to inquire into the facts. We want to have systems where, and this is a very difficult one for me because I've been involved as a chairperson at one of the universities systems that don't encounter many delays. And unfortunately, this is something that is plaguing a lot of these systems, is when you have so many actors involved in these disciplinary hearings, delays are common, and it makes these things continue for months, which is very harmful to the victims, because they do feel like this is never going to end. Also, something that I've seen is trying, and this is when you allow attorneys to come in any way in these procedures, which I've noted that many universities have you actually have to do applications to say why you need an attorney, is when you allow attorneys into these systems, things become overly procedural. Everything is a case within a case, and this rule in terms of this for this more this section wasn't followed, and this has got to do with something that is not substantive, but is about the procedural rather than the actual factual, and it bogs down the entire process, and it becomes something of what we see in the courts at the moment, and is replicated in kind of our when you allow attorneys to go into domestic violence matters and things like that. So trying to create systems where we don't allow the overly legalistic processes. So what I'm really trying to get to through all of this is, yes, I do think cases like Andy Kawa's are important, not only in showing that trauma, not only showing through law, that through our legal system and the acknowledgement of a legal system, that trauma can be created through these processes and through problematic investigations and perhaps through problematic hearings, but also that universities have obligations in terms of the Constitution to make victim-friendly approaches, and that universities, not in a threatening way, but universities may come to see similar cases launched against them where they haven't had these types of processes, where the investigations haven't been victim-centered or haven't been sufficient in a way. So instead of it being a warning of things to come, it's more of a conscientizing of ways it should be in the future, because these cases are being acknowledged by our judiciary. These cases are becoming part of our victims' rights jurisprudence, and they should be replicated in universities going forward. Thank you.
Thank you so much, Dr. Schwemmer. I think it's I'm certainly interested in looking outside of a legal process or a kind of criminal process. What sanctions can be imposed on someone who is found to have acted in a sexually exploitative or coercive manner? Because it seems that our reliance on the criminal justice system is kind of a cop-out, because typically no results come from that. And what is the alternative? But our next speaker is going to be Francesca Fonsa. She's the CEO of the Angelus brand, national champion for women, a Sisulu Women of Fortitude, founder, Women Integral Impact Network founder. So, I mean, her CV runs for about 3 pages. I'm not going to read all of it. Very, very impressive. She's going to be our next speaker, and then we'll break. We'll have a discussion after this and then break for lunch. So thank you. Francesca Fonsa is our next speaker. Thank you so much.
Thank you, Karen. Yesterday when I was preparing for today, I looked at the general consensus of what gender-based violence is. And I found a very interesting perspective that says GBV is rooted in gender inequality, but not exclusive to the unequal access to power, which leaves the female gender, women and girls, vulnerable to violence, harassment, and exploitation. Now, when we consider that, then we address the fact that gender-based violence in all its forms and manifestations is in fact a human rights violation. It does not discriminate race, ethnicity, or socioeconomic circumstance, and occurs across all sectors of society. In my personal experience, a staggering 8 out of 10 women will experience some form of physical, emotional, economic, or sexual violence or some form of abuse in her lifetime, usually by, but not exclusive to, an intimate partner. Now, we must also remember here that manipulation in relationships it's also a form of subtle violence. And we need to look at ways in our institutions, but also in society, to train and teach the instruments of nonviolent communication. I know the official stats set this figure at 1 in 3, but that is based on reported statistics. So that is why I want to make it very clear. It is my personal experience and our own research. As gender-based violence can occur at any point throughout a learning institution, every entity of higher learning should have a role in addressing gender-based violence within itself, its internal processes, and across its external relationships, its supply chains and associations, in its society at large, including its educators, students, sponsors, and their communities of influence. This can be done. What is not apparent from what was said of me is that I'm a member of the United Nations Global Compact, and I have been interviewed last year and also this year with regards to business strategies, and very much into the fact that in our company and every conglomerate that I deal with in terms of impact projects, I insist on a morality clause. And that is something that can be addressed later. When we look at when gender-based violence was declared a human rights violation, we are looking at 1948. It's 74 years later, and we are still just beginning to scratch the surface. And therefore, I'm going to allude to an address to civil society that I did last night. And it specifically focuses towards epigenetics, neuroscience, and the developmental aspects of gender-based violence. Now, first of all, I want to please express, we all carry traumas. All of us carry intergenerational trauma. And, you know, I don't believe that some carry necessarily more than others. We all have trauma relating to various aspects, and I will allude to it in a minute. What I want to make very clear is I don't believe intergenerational trauma should become our excuse. It should become our motivation to change. When we look at the general definition or understanding of epigenetics, it alludes to the non-genetic influences on gene expression. I would like to phrase it as past painful experiences and wounds that has been internalized into energetic imprints upon gene expression and passed to future generations. That is my personal understanding of epigenetics. When we look at epigenetics in the GBV environment, it is very often that it concludes that generational trauma originated as personal violence, bullying, domestic violence related traumas growing up, within the family context and very often in the learning environment. Epigenetics and neuroscience has now presented the scientific premise that thoughts and emotions are processed in the brain the same way as physical threat. It concluded that every degenerative disease, in accordance to the lead researcher of the Chicago Health Institute, Dr. Clausen, create the same neuroresponse. In other words, we know that cardiac disease, critical vascular disease, adult onset diabetes, obesity, Parkinson's, Alzheimer's are examples of inflammatory disorders that originated and had a non-genetic influence on gene expressions and then therefore became hereditary. This was published in the Chicago Health Institute's journal in 2021. Now, epigenetics creates environmental stimulus reactions. It's conditions arising from non-genetic influences on our gene expressions, as I've said. So now you are an entity, you are a human being growing up, and you've already got the dispensation of your genetic provocations and possible rationale that you, and now you're growing up in an environment where you are not taught the instruments to move past that trauma response of the amygdala and get to the rational mind, which is stimulated by the parasympathetic nervous system. And I think, you know, we are a complexity, but we don't need to be so complex if we would just address what in our awareness and also in our new information as it becomes available to us as a society, to incorporate these accesses and create instruments in our educational environments that would assist people in dealing with the external stresses. I know, you know, it is probably most effective in children between the age of 5 to 9. And I know our success rates with children, with people over the age of 35 is only about 11%. But, you know, we have to start somewhere. For the first time, we can look across vast literature and confirm that brain size and structure is different to males and females. We should no longer ignore sex in neuroscience research, especially when investigating psychiatric conditions that are more prevalent in either males or females. Then Amber Ridrock, professor in Chicago, she said the burden of pain is substantially greater for women than men. And that led pain researchers like myself to wonder if the pain perception system if it's different in men and women. And I'm myself are personally pondering that. If we look at epigenetics, neurosciences, our external factors at play, the various types of trauma, what is the socio-psychological impacts of gender-based violence? How is it determined to manifest as genetic trauma? What makes it relevant to intergenerational, dissociative and bonding traumas? How does all these things create unconscious triggers which manifest as gender-based violence or violence in any form, really? If we look at trauma, you know, we've got various trauma definitions: mental trauma, psychological trauma, behavioral trauma, suppressed trauma, internalized trauma, physical trauma, cellular trauma, which alludes to epigenetics, of course. And now the dissonance aspects, you know, we see more and more. It started in the 80s with the ADD, and now it's just more conditions that are prevalent as society develops. And we had to look at all these things, what affects it. And yes, I think some of it is even chemical. It's in the foods that we eat. It is in, you know, various aspects that we need to take a very holistic and comprehensive look at. And when we then move from the developmental aspects of gender-based violence and how trauma responses can trigger us and trip us, then we also have to have a look at the economic impacts of gender-based violence. Because now, as Steffi Wagner has said, pain travels through family lines until somebody is ready to heal themselves. We have to break that cycle of intergenerational violence. And it has to start with us. You know, epigenetics prove to us that our ancestral trauma or intergenerational trauma is a problem. Our first step is to understand that it is a personal problem, that it affects us personally. Secondly, that it is a collective problem, that it can affect us in our groups, our nationality. Very much, you know, for the Jewish community, the Holocaust was a collective trauma, and apartheid presented traumas in various ways for various people. We have to look at all these things and how historical traumas also manifest. You know, we are living in a world where there's conflict every day, and a lot of that conflict is historical. So we cannot escape the human genome configuration and our epigenetics or neuroscience and how it manifests as we progress as a human race. We are very much focused on the human race rather than our humanity. And when we look at the economic impacts of gender-based violence, we have to look at what happens. Economic abuse of the female gender has been the norm, along with exclusion to inherit, which only started to change around about 1833. But it's still not changed for all today, because we as a society normalize these attitudes and we create the conscription. So women have always been at the short end for many eons when it comes to the manifestation of gender-based violence, and a decrease in the productivity of our workforce, and especially females, because of absenteeism. But in the education environment, poor academic performance, dropout rates, that very often accumulates to institutionalized stress and the future of female students. As female students that has to perform sexual favors for academic performance, or a woman that has to do sexual favors in a work environment, that is institutionalized rape. It cannot be seen as something else. We really need to start understanding what it is we're dealing with. And I agree, we cannot only look at the traumas of the female gender. We have to include all human beings, because we are in this collective consciousness ultimately that plays a part in everything that we do in the progression of the humanity, our planet, whether we're looking at sustainable development goals, whether we look at the unwarranted impacts of legal costs on victims. You know, when a man has not paid his maintenance for a long time and a woman has got to enter into a legal path to recover that cost, by the time, you know, the court has had its verdict and there's a court order in place, if you subtract the legal engagement and the cost thereof from the final amount, the woman still loses. Poor health due to gender-based violence causes, poor human resources, victims' physical, psychological, and spiritual well-being. I think we really pay too little attention to our spirituality. It all has a significant negative impact on the economic human capital and the gross domestic product of our country. And in conclusion, I want to say there are methods to support and refocus our challenged societies towards peace and most definitely consequential learning. Read the attachment, the undoing, bonding, whether it is a child bonding to the mother, negative bonding in relationships, or other bonding traumas to our ancestral traumas, if we are looking towards implementing empowerment tools, techniques, and strategies for our learners across all learning strata that reduces stress, directing individuals to be focused and partake effectively in their own learning processes. I have to step over to another meeting in the Department of Justice, so I'm going to conclude with that. And I wish you all an incredibly powerful session for the rest of the day. Thank you very much.
Thanks. Thank you. There are a lot of questions for Dr. Schwemmer, and I think the one of the first on the chat is Dr. Schwemmer posits that a disciplinary process should adopt a more inquisitorial procedure rather instead of the prominent adversarial system. The adversarial system relegates the victim to the status of a witness, which removes them from the center of procedure, unlike the inquisitorial system. The criticism that including a lawyer in an attorney in the DC procedure renders the process too overly procedural is precisely the kind of outcome that will prevent DC procedures from being too mechanical. Checklist that is void of substantive justice. I mean, I think I wanted to ask Dr. Schwemmer, you know, oftentimes we see, I think we saw this with Rhodes in November last year, where I think there was an allegation of a inappropriate sexual contact or potentially coercive sexual contact between a lecturer and a student. And the university stance was, well, I think the student had laid a criminal charge, and therefore they didn't want to overlap with that criminal case. And of course, the case then went nowhere. Do we see this kind of thing happening where universities or institutes or higher learning are very happy to just pass the buck to law enforcement without properly going through a proper process themselves, because they're just saying, well, it's in the realm of criminal law now? And how do you deal with that?
So I wouldn't be able to say, because I've only really dealt with UCT and BITS. I'm at BITS. So I can't say that they would rather it be dealt with in the criminal process. But I can definitely tell you, and it's replicated when you get things like people in domestic violence cases in those courts, is that the ball is often kicked over to the criminal justice side, because, as you say, people say you could just go and report this. So often it is a scapegoat that you could always go and report this. Although, as the other speakers have said, there's not a likelihood you're going to get anywhere with reporting it. But it's also sometimes playing on the miseducation of individuals around kind of these different prongs that we have with regards to accessing justice, is that in universities, in domestic violence situations, you can use your university systems, the disciplinary systems, whilst going to the police, and also going to get a harassment order. And I sometimes think that because people are different kind of organs or different kind of groups, like the police, like the clerks of courts, like the gender equity officers, are often undercapacitated and are stretched, they will kick it over to somebody else. And it's not fantastic, but I do think it really rests on the fact that people do not know that they can approach different entities all at the same time, and that those processes should, and they are supposed to, continue without each other or without the influence of each other. So you don't need to be waiting on the criminal justice system, which you will wait for many years to get any kind of outcome on. But I do think it is kicking it over for various reasons, including capacity.
If you had to describe what an appropriate university response is to an allegation of GBV, for instance, be it an allegation against a student from a student against another student or a student against a professor, what is the best kind of way that process unfolds according to your experience in a way that isn't re-traumatizing, that doesn't put the victim or the on trial? Like, in your experience, which kind of processes work the best?
So I do think from what I've seen and what I've read is that both UCT and WITS endeavor to have very good processes. And I do think it's processes that both involve supporting the survivor and also listening to the survivor and what they want. So I think a lot of the time, and you'll see it in a lot of court cases, especially when women disclose the names of their perpetrators, especially online, is people will say to them, why didn't you go the criminal route?
Yeah.
Is deciding what kind of justice people should have. And I think processes that enable the survivors to choose the processes they want is also very important. And I was initially not in favor of mediation for a lot of these processes because I do see the unequal power had by perpetrators. But I've come to acknowledge that listening to people, and if that's the types of things they want, that's the types of things that should be made available to them. And I think a lot of these universities do have a whole range of forms of justice that can suit the individual. But I do acknowledge that they work within systems that are very oppressive. And these gender equity offices are underfunded and severely undercapacitated when they actually are one of the most important entities at a university. But I do think the victim approaches that they have been taking over the last couple of years are fantastic.
Well, we've got a message from Charlene Bierkes Mabaso, who says, I am at WITS, heading up our gender equity office. We would much rather not deal with matters in a criminal way. We know the realities of reporting to SAPS and know that this does not provide much recourse for students or staff. We do accompany individuals who wish to go to the SAPS, but we deal with all complaints that are brought to our office, and at times do this in parallel to other processes. And it's exactly what you're saying, because sometimes I think, when someone has an experience where their consent is taken away, you can't re-abuse them in a process by saying, well, this is what we're going to do. This is what you must do. This is what you must do. So you're raising a pivotal issue. It needs to be in consultation with the survivor.
Especially if you can't guarantee, you can't even guarantee a system, because I mean, we're under an 8% conviction rate from time of reporting to conviction. You can't even guarantee any likelihood of conviction.
Yeah.
If it's an 8% chance, then it's almost foolishly saying to people, go out there and report when you know that there's no probability, there's no likelihood of success.
Yeah.
So it's almost self-defeating, and it's incredibly harmful to send people out there with you should at least be advising people of these types of things. The conviction rate isn't great. If they want to pursue the criminal justice route, it's good to support them in that. But it's always making the survivor aware of what our system is like, that it's incredibly weaponized against victims in many ways. Our police system is very problematic. It's filled with beliefs in rape stereotypes, unsympathetic individuals, for various reasons, also being undercapacitated. But it's at least allowing individuals to choose paths when they have enough information about those paths.
And the reality is that you and I both know that the rape cases that the NPA is willing to prosecute, Bronwyn also referring to this, is exactly what some of our, the responses we've seen is the perfect victim. You must be hit over the head. There must be violence. You must not know the perpetrator. You must not be drunk. You must be completely sober. You must be observing every single thing that happens to you. And you must be able to mentally withstand being put through hellish levels of cross-examination. So in a scenario, which is often what's in universities, alcohol is involved. This is a person as we've seen with the Goko case, which is now going to the SCA. There may have been foreplay. There may be, there's all these, and it just seems very much like our criminal justice system is completely incapable of dealing with those matters in ways that are not massively traumatic, again, to the victims. If, and that's a big if, you and I both know, they actually take those cases to court.
Yeah, I mean, and also the cases that they ill-prepared for cases where it's intimate partner violence. But I mean, it's not just our criminal justice system. It's criminal justice systems are not made. It's not written by the survivors. It's not written by people who are victims of sexual violence. These systems are written by white men in many cases that are violators in many ways. So when you have people that are your oppressors writing the tools that you're supposed to be working with, it makes those tools it makes those blunt tools. They're not working very well. So when Bronwyn says groups like Women's Legal Center and CALS, we're trying to make these systems a little bit better. But the tools the tools can't be used because they're problematic in their formation. So that's where university disciplinary hearings, these types of departments, are incredibly important and have this unique chance, like Bronwyn had said, at creating something different. They don't have to replicate the problematic criminal justice system.
Just a question for you. How do institutions and centers such as CALS, law clinics, and student counseling make themselves more accessible to students? Usually we only hear about them when something has happened. Students do not necessarily know that they're there. So, I mean, what you're saying is incredibly valuable for someone who has gone, you can be but how do people become aware of you and how do they access you?
Yeah, so I mean, even with us, and I speak, and I don't want to speak on behalf of them because maybe they should be in the room too, is these kind of gender equity offices like the WITS one, like the UCT one, and I've met various ones because there's actually a group of these units that meet often, is that these groups are only made up of 3 or 4 people. Yeah. So with regards to making you aware, these people are running hearings every single day. They're doing it. So I don't want to say it as an excuse. I'm saying we need to be putting them out there, but universities need to be taking this seriously. Is you having departments that are having 3 people when you're having a scourge of violence on campus, a scourge of violence in our society? Put your money where your mouth is and capacitate. You need staff to not only be caring for your individuals with psychosocial support, the people running the hearings, but you need people also being able to go out there and do the advocacy. Universities have no real interest in changing this if they're not going to resource these groups, because they really are tiny entities.
Yeah, absolutely. And just in terms of, in a kind of inquisitorial process, some might turn around and say, well, someone has they've been accused of sexual harassment or violation or whatever. What kind of effective sanctions in those situations exist? Because, I mean, I think the rhetoric, the kind of nuanced conversation that we've had has been about, we respond to violence with violence. We respond to trauma with trauma. It's like lock them away, throw the key, which, all of that kind of rhetoric. But outside of a criminal justice system, what have you seen to be some of the more effective sanctions in dealing with people who have violated, abused, sexually harassed. I mean, how do you actually come up with sanctions that are effective in that context?
I mean, it's difficult for me to say because I'm not qualified with regards to things like rehabilitation of individuals in that way. But I do think that programs that are offered around conscientizing people and trying to educate people around prejudice are important, more as a preventer than necessarily an answer to the actual perpetration. I don't think punishment in and of itself assists greatly because we see that often violence reoccurs. It continues even after perhaps someone may be released from prison or something like that. So I think we do really need to listen to our experts that are out there, because there's this idea, especially in carceral feminism, is this idea of locking everyone away, which you've just said, which isn't working. In various ways, we have very violent crime in our country. Locking people away is not preventing violent crime in our country. We're not going to lock everyone away, but there is something that needs to be looked into, other ways that people are rehabilitated with regards to violence. Gender-based violence, but other forms of violence, and this isn't working. Using laws to deal with everything and incarceration as the kind of silver bullet it's not working. So I'm entirely with you, but I am not qualified to say how to deal with it exactly.
I don't know if anyone else has questions on the floor or questions that they want to ask at all. But I just wanted to ask you something. I've interviewed many, many, many rapists, and I can only think of one example where it was a young man who was 18, where the rapist actually admitted that they'd raped. In fact, when my colleagues and I were at ENCA, they were trying to produce a documentary on rape, and the difficulty was none of them would admit they did it. There was always a story. There was always, yes, but even in circumstances where they didn't know the woman. I had a horrifying experience once when I did a trial with someone who was convicted ultimately of the rape and murder of a 5-year-old, and he said she'd consented. So one of the difficulties is that I think maybe it's to do with this idea that we have of rape as highly violent, highly coercive, has to be a stranger, all of that, that even, like particularly with date rape scenarios, the perpetrators will often be incredibly resistant to even acknowledging, that they may have, they may have crossed lines, that they may have not heard someone say, that they may not have respected someone's no. We see that with the Goko case. So, I mean, it's a tough question to ask you, but like part of I think for survivors of sexual violence, and, speaking as myself, one of the most important things is to hear that person say, I know I did this. I know I did this. You didn't make it up, because of the gaslighting that surrounds it. But how do you get that in a process where people are scared that, there's all this legal, there's concerns? How do we actually get men to really acknowledge how important consent is, and to acknowledge when they have not heard someone say no, they haven't respected someone exercising boundaries over their own body?
Yeah, I mean, and as you say, I might not be the correct person to answer that in many ways, because I don't know the psychology of perpetrators. But I do think I had spoken to a male friend the other day, and I had said, do you think you've ever committed like cases of sexual harassment and things like that? And he said, now that I've tried to engage better with what sexual harassment is, I actually don't know, and I might have. And I mean, that's not saying rape even. It's about things of educating people around what these things are, but it's also about the very clear inability or unwillingness to listen. Like you've said in the Coco judgment, it was very clear that this individual did not want to engage. There was both her verbal but also physical kind of acts against that. And it just seemed that there was a wall, an inability to want to hear. And I don't know how we deal with that, but it's just that inability of wanting to hear, because and I always say this, in any other situation, you would know that that person didn't want that type of thing to happen. I always say, like, if somebody offered you a cup of tea or something and you were pushing them away, or you were taking your hand so you can't take it, you would know that person doesn't want that. But then when we translate it to these situations, it becomes so confusing for individuals, and I don't understand that either.
Yeah, I think that's an incredibly valuable point. Jane Argyle, I think, raised her hand.
Yes, thank you. Just a little comment. Can you hear me?
Yes, we can.
Okay. Just to reinforce what you've just said about offenders and perpetrators, from the perspective of offering program work to help prisoners prepare for reintegration in the province of KZN, I can state definitely that sexual offenders are the least tractable to program interventions, the very least.
Absolutely.
They're the ones who think GBV is a terrible thing, but nothing that they would ever do. And as you say, there's always a story. I blame her mother, I was framed, that sort of thing. I didn't do it, it was consensual, etc. And, I've been puzzling through this and think, well, we're wasting our time a little bit. Maybe we're just working in the wrong area. And maybe we need to go back to what the previous speaker, was it Dr. Schwemmer, said about trauma and intergenerational trauma. There's something in the South African psyche which has been unable to release the trauma. And it's manifesting in ongoing and cyclical patterns of gender abuse and a reinforcing and building of a very, very problematic masculinity in our country. I don't know how you address that, but to try and go to the source of what's happening, to try and identify the source perhaps. And I think that Dr. Schwemmer had something in it about the trauma that needs to be addressed first. Thank you.
Thank you so much. Prof. Madonsela, did you want to say something? Yeah.
Thank you. Just a quick one. I think the one who spoke about trauma was Dr. Afonso.
Yeah. Afonso.
Yes. And I agree with Jane Argyle, though, that that's an area we need to look at more closely. But be careful, again, not to give people excuses. Look at it closely as part of the solution, but navigate it in such a way that it doesn't become an excuse. But what I did like about her approach is that a lot of people, when they talk about trauma, they make it a black issue. And that has implications of making trauma-based GBV or trauma-triggered GBV a black problem. And I liked her approach because it's in line with the book that I have, Apartheid, the Bastard Child of Britain, that talks about literally every group in South Africa went through trauma. The English were traumatized by the Romans, the Afrikaners were traumatized by the English, and then et cetera, et cetera. So I think I would like us to look at that further in terms of how do we take it forward. But my question is to you, our remaining colleague here, Prof. Schwemmer. I think I've lost myself. What was my question? Sorry about that.
It happens to me all the time, don't worry.
It does. Okay. As a lawyer and as from CALS, I used to be with you guys, so I have formed memories of working there. I have an issue, and it started with my days at CALS. I have an issue with our European imported criminal justice system. And it started with me visiting the rural women's movement and telling them we should bury these chiefs' courts and take everything to the magistrate's court. And the women, we were at a place called Kwangema, they said, no, we don't want to go to the magistrate's court because when we get there, we don't exist. It's all about this person in state, they don't even have to talk. But the worst part, they said, we get nothing. When we go to the chief's crawl, at least we get a cow out of it. So it's a perennial question that I've been asking myself about the fact that we are an African country where people's disposition is a fusion between criminal justice and civil justice. If somebody steals my cow, I go to somebody who can help me get my cow back. The system we're imposing on people is if somebody steals your cow, we will forget about you, but we need you as a witness. I've even witnessed a case where they said, well, we don't even need him as a witness. He wrote a witness statement. This was in a university setup. We said, okay, we have the statement. We don't need him as a witness. We'll proceed without him. And the question is, who are we restoring? My understanding is that the European system was crafted in that way because people belonged to kings. There was serfdom, whereas in Southern Africa, we never had. In Sub-Saharan Africa, we never had serfdom. Of course, if you wronged a serf, you would go to the owner. Here, people never belonged to chiefs, and that's why the Ingwenyama Trust decision is a correct decision. Should we be having S versus Dlamini or S versus Rawlings, or should we be Mazibuko versus Dlamini assisted by the state? In other words, the state should be assisting the person who has been harmed by another human being and who is the human rights holder to be restored as close as possible to where they would have been but for the wrongful action. I know it's a long story, but it's something that really, really bothers me a lot. And whenever I have an opportunity, I've written about it. Thank you.
Yeah, so no, I agree entirely. I think the problematic use of state versus, it's problematic in many ways, and Bronwyn had spoken about it with regards to us needing representation for complainants. But it does erase the complainant in the case. It also works on the state versus the offender, works on the idea that it is for the betterment of society. And which is fair enough, because in many ways it might be if the perpetrator were to perpetrate to others, but it does make the complainant disappear in many ways. And it does put the complainant's interest second to that of the state and society, in that if they want to proceed in a certain way, they're going to overlook the interests of the complainant. And it is a question of whether we can break open and create, as I say, more victim-centered approaches to the way the criminal justice system works. And that is things like representation of complainants in matters. I've argued about ways for victims to have their voices heard with regards to victim impact statements and the use of those. It is really interrogating whether that system is working for us and what ways we can change it. But I'm entirely in agreement with you that the African system is preferable in many ways, in that it does acknowledge the individual as well as the community. As an Ubuntu approach, would acknowledge the individual and the community as having value, the individual as being part of the community, the individual and the best interests of the individual is the best interest of the community, and vice versa. And I don't think that translates into our law, because we've used this colonial legal system that only looks at the state, only looks at the like you had said, it's very it looks only at those that are the owners of the individuals rather than the individuals themselves. And I do think we are working, and many organizations are trying to use the system, which is a problematic system, which is the criminal justice system we have, and trying to make it a friendlier system for complainants. But it is, as you have said, it's a problematic system that we have imported, and it's a problematic system from problematic forefathers who had made that system.
Thank you so much, Dr. Schremer. That was a brilliant submission. We're going to wrap it up now and have a lunch break. We'll be coming back at 2:30 for the last 2 plenary sessions, and you will have eaten food, so you'll be lots of energy and full of questions. So looking forward to that, but we're going to have a break now. Okay, thanks, guys.